Sure, abuti honestly.
Thank you very much, Chair. Good morning, is it still? Good afternoon to everyone. Now, Chair, I just want to start where Honorable Maduna left off in terms of the Judge Desai judgment as an ombuds. I want to just know one of the findings, or rather, yes, that he had made was that all the lawyers that were utilized in that disciplinary hearing must not be utilized anymore. Are we still using them? Kulufelo Masedi, Ajay Chagan, Bob Makumba, and Isaiah Mureriwa. Are they still in your panel for disciplinary hearings?
Kolofelo Masedi was actually an employee. He was the legal officer who dealt with the matter. He's since left our employee. He's joined the SIU, in fact. Yes. The other members of that panel, we are still using them. I'll be honest about that. They felt very aggrieved about the comments by Judge Desai. I think whether it is correct for Judge Desai to make a ruling to say that they are not allowed to be used, for me is open for discussion. I don't think he has the power to make that ruling. But yes, we are still using them on our panels. And they perform extremely well.
Did you take Judge Desai's finding for a review? So why do you feel that he is in no position to make such findings, and you don't subject them to a process which is going to either agree or disagree? Why do you feel that the ombuds is meaningless to you?
So it's not to say that the ombud is meaningless. By no means do we say that. And we also have a good working relationship with the ombud. In our view, that was a recommendation made that exceeded his powers. He cannot dictate which members sit on disciplinary committees and which members do not.
No, you are wrong. He is an ombud appointed to make sure that whenever these kind of issues arise, he becomes the final arbiter. And if you are not satisfied with the final arbiter, then you subject his findings to the higher courts so that they decide against. So you can't then come here and blame Raf, who is also arguing in court, rightfully so, for not paying things, yet you are the ones that undermine the ombuds's finding and say he has no powers to do such. Based on what? When you have not subjected it to a rightful process, which is a court to go and review the findings of the ombud.
Chair, may I come in? I take the honourable member's point, and I will take it up with council and see if the recommendation must be implemented immediately, or if council decides to review, to send it back for a review.
So all of you, you didn't know you have to do that?
Discussion. I don't think he has the power to make that ruling. But yes, we are still using them on our panels. And they perform extremely well.
Did you take Judge Desai's finding for a review? So why do you feel that he is in no position to make such findings, and you don't subject them to a process which is going to either agree or disagree? why do you feel that the ombuds is meaningless to you?
So it's not to say that the Ombud is meaningless. By no means do we say that. And we also have a good working relationship with the Ombud. In our view, that was a recommendation made that exceeded his powers. He cannot dictate which members sit on disciplinary committees and which members do not.
No, you are wrong. He is an ombud appointed to make sure that whenever these kind of issues arise, he becomes the final arbiter. And if you are not satisfied with the final arbiter, then you subject his findings to the higher courts so that they decide against. So you can't then come here and blame Raf, who is also arguing in court, rightfully so, for not paying things, yet you are the ones that undermine the Ombud's finding and say he has no powers to do such. Based on what? When you have not subjected it to a rightful process, which is a court to go and review the findings of the Ombud.
Chair, may I come in? I take the honourable member's point, and I will take it up with council and see if the recommendation must be implemented immediately, or if council decides to review, to send it back for a review.
So all of you, you didn't know you have to do that? You didn't know the process to review an Ombud's
No, we know.
finding. So why was it undermined?
An oversight on our part, Chair.
No, it's not an oversight.
It was.
I'll tell you, it's not an oversight. Chair, we are faced with a situation of let's push everything to Raf and nothing from our part is wrong.
No. That's definitely not the case, honourable member.
So can I, just give the member an opportunity to finish her comments, and then you can respond.
Now, can we then get, if it's not on your part and you agree that you were on the wrong, can we get all the people whom were mentioned, which I've just mentioned, to be placed on hold until the court says, I overrule what the ombuds have said?
Chair, if I may, the honourable member is presenting us with a legal conclusion. Now, I must admit I'm not entirely familiar with the subject matter of what the honourable member is raising. But the status of the comments of the Ombud are a matter of fact and of law, and we would need to properly consider those as to whether they constitute a matter which can or ought to be taken on review. And I would therefore suggest that we be given an opportunity to look at that and, if necessary, to report back to this committee. I wouldn't want to commit us to a course of action based on what is being presented to us as a slam dunk legal argument when in fact may not be so.
No, it is so, sir. Because then the need for this country to have an ombuds on matters of legal experts or legal issues, there isn't going to be. If the findings of an ombud can just be clearly swept under the carpet, or rather ignored and undermined, then there's no need. Because once an ombud says, we are making the following findings and are making the following recommendations, therefore, if you are not satisfied with that, you ought to subject that to another process which is higher than the ombud to make sure that you set aside the findings.
We'll take all this under consideration, Chair.
Meaning which everything that is in the finding cannot be overruled by you, like the utilization of the lawyers that are now sitting in DC having banked and destroyed lives of the people in another DC that they have sat in, and they did not conduct themselves ethically in that DC. Until you subject the finding that they acted unethical, then you can utilize their services. Because the Ombudsman did not just arrive at that conclusion on the basis of vibes. It's on the basis of facts.
So as I understand it, and I too, Chair, am not au fait with the facts, but the Ombudsman can make a finding, can make a point of view, and then can even make a recommendation. So as my colleague is saying, unless, and I'm not sure if it was a finding, if it was a point of view, or if it was a recommendation, as I say. I wasn't there at that stage. So we would need to understand what it wasn't stated in the initial background is that the current council only began its term in November of 2024. So yeah, some of the stuff we know from the media. But as I understand, yeah, the Ombudsman can make a report, can make a finding, and then or point of view. And I'm not sure where we are.
I don't know how your carryover was done. If you had taken, when you take over office, someone does a handing over of the work, and that is in your space. Let me go forward with my question.
So, Honourable Mente, I'll suspend your time here because I do need to just understand something. So, in the ordinary course, when the Ombudsman makes a ruling, what's supposed to happen out of that ruling?
It obviously depends on what the ruling is about. And I'm just quickly trying to see if I can find the report from the Ombudsman. As you mentioned, it was not on the list to prepare for. So we have, for example, instances where the Ombudsman made a ruling to say that they're unhappy with how the matter was investigated, and we need to refer the matter back to a committee. And in those instances, we do that. Obviously, there's a process that needs to be followed when the Ombudsman receives a complaint. And there's engagements between the LPC and the Ombudsman's office to investigate and to assist with the investigation. But really, it depends on what the matter relates to. I think it's difficult to give a blanket explanation in the absence of context.
No, look, I mean, the reason, I mean, I have the same concern as Honourable Mente. Right. The reason I'm asking in the ordinary course, because there was an answer here that said, in our opinion, we felt that they should continue, which means somebody carefully considered the ruling of the Ombudsman and took a decision to act contrary to what it says. Now, if that's the position, and I'm assuming that it was carefully considered, it can be difficult to provide a reason, having stated what the position is, first of all, and secondly, even for the public to know, okay, so what's the use of this Ombudsman? Exactly. If sometimes what the Ombudsman says is going to carry weight and what the Ombudsman says is not going to carry weight, it appears, therefore, to be a toothless bulldog. So that's why I'm not allowing Honourable Mente to proceed to the next point, because it remains undealt with. But I now need to understand on a principle. Isn't it that what's supposed to happen, unless somebody feels aggrieved as a result of the outcome, what the Ombudsman says is supposed to be done? On a principle. And there are ombuds all over the place.
Chair, may I request that we provide you with a written response? And if I can then ask Honourable Mente to maybe formulate a concern and additional concerns that you've got, and we can address those in writing.
If you're not too familiar with the specific case, sure, I'm asking on a principle. I'm asking on a principle. When the Ombudsman makes a finding and makes recommendation, how do you decide what to implement and what not to? And what's the use of the Ombudsman if there is no process that guides what then happens?
If I can just use an analogy, because as I said, I'm not familiar with this case. A judge might, in a judgment, express opinions about the competence of an official. But in the end, the only part of a judgment that has binding force in law is the order that is made at the end of that judgment. So if a judge comments that an official appears to the judge to be incompetent, it doesn't follow that that official is now going to be dismissed for incompetence. And that's the analogy we use. Yeah. So one has to look at the statutory framework within which the Ombud works. One has to look at the status of what was before the Ombud, under what provisions of the statute he was operating, and what the status is of the comments that he made concerning whether these people should or should not serve on a committee. You talk about a ruling. I, for one, don't know that there was a ruling. That's the first thing one would want to know. Was it a ruling? And if it was a ruling, what is the status of that ruling? Is it a recommendation that we're entitled to follow or not to follow? Or is it something that is binding on us? That's what we need to look at.
Okay, I'm worried I'm disturbing Honorable Mente's flow, but I am just not satisfied with the answer, because, you see, if the initial answer to Honorable Mente had been, Honorable Mente, we are not completely familiar with what happened here. Can we check and come back to you?
Councillors, we are not officials of the LPC. So we sit, when the council sits however many times a year, every 3 months or so. Our colleagues to the right of us are officials. They deal with the day-to-day operations of the council. So they know that operationally what has happened here is that those panel members continue to serve. We as councillors, we wouldn't necessarily, well, certainly I was not alive to that fact now. Whether it's something which came across our desk in the last year or 3, I don't know. But the fact is, as I sit here, I don't know. So the initial question was able to be answered to say, yes, those people are still serving. That's a factual question. We then asked, well, don't you have to take that matter on review? And that's when we come in and we say, that is a matter to which we will give proper consideration. So it's not a question of answering and then not answering. They are different questions.
Honorable Mente, I am eating into your time, so I'll see how much time I've got in the end to untangle this whole thing. My apologies, but I got stuck at the same place as you. It helps if you switch off the mic when another one is on. Otherwise, the people watching at home can't hear. Thanks.
Thank you, Chair. I will submit the question, but I think Secretary has captured the essence of that question. But in addition to that, don't you find it strange that DC, which said to discipline the legal firms, the 2 companies, arrived at a conclusion of a fine to certain directors and exclude them from a crime which allegedly was committed by one of them, but say nothing about the proceeds of the clients? What was paid to the clients in that DC? What was the conclusion of the DC where clients are concerned? Because this case emanated from clients who brought a complaint to you that these law firms are embezzling our money and they are not paying us, yet they have received it. And one of the whistleblowers was the insider at the firm, whistleblowing to you as well that what is happening here in this firm is dangerous, is brutal, and is not acceptable. I'm not going to be part of it. Ethically, I'm not agreeing. Morally, I'm not agreeing. It's criminal. So why don't you find it strange that they would arrive at a fine, yet say nothing about the clients?
So the clients always have the recourse to recover their losses. And I know that the majority of those clients are now represented by another attorney who's assisting them in prosecuting the claims.
What recourse is that? Because the clients came to the LPC as their last resort. Fortunately, they had money to even find people to go and draft papers and come to you. For another person somewhere in Mutu, they don't have that money to do that. Now we're talking about people who have money and means to get well-educated lawyers and experienced lawyers to come and present their case to you. Yet you arrive at a conclusion without the very same people who brought these people here.
Sorry, Chair, if I might just ask clarity. When you say we arrived at a conclusion without those people, can you clarify that?
Yes, all of them were not called to the hearing to present, and the conclusion, or rather the finding of the DC, did not have anything to do with the clients, and nothing was communicated to them except that a lawyer was called after the fact and was told this is an agreement. If you disagree, you can go elsewhere.
So, Chair, I don't want to go too deep into the specifics of the matter. The information that I have is that the same attorney representing those clients now was actually present when this matter was considered and the settlement was done. So if there's different information on your side, that's not the information that I have.
Okay, here's what I'm going to propose, Chair. Go back and look at that case and look at the ethical conduct of your own people who are supposed to be helping people. And then you answer us, especially based on this one particular case. There's a second one which Ground Up took to court as well, complaining about a law firm who did not want to be published, in the case of the lottery, Chair. When a publication, which is in the media space, wanted to publicize some of the information with the SIU has got, where he forged signatures on statements, those statements that were accompanying the documents which allowed them to receive monies from lotteries on those cooked up NGOs and everything. He then took the paper to court, refusing that all this evidence must be publicized. And the court again overturned that. But when that particular person went to court, again, when they came to you, to the LPC, again, the LPC did not act accordingly. I will give that case as well. Now, Chair.
All right, so you 4.5 minutes over, but ask one more time and then we're done.
Okay. No, sorry, Chair. Here is one thing that is paining me. Two things I'm going to request from the LPC. They have given us information of a number, cumulative number of cases reported and cumulative number of cases struck off the roll. I'm very much interested on, based on the cases I made, because where I was going is in your report. Based on the cases I've made is that the LPC disciplinary process itself is not pure. And all the cases that were struck off the roll as cases that lack evidence, lack substance or whatsoever, can we get that list of why did you not pay attention to case A and not give it to us cumulatively? Because at this point, it doesn't give us a picture. And then?
So, Honourable, you mean struck off or dismissed in court?
No, dismissed by you and not gone, or even by disciplinary hearing that here there's no case. Because you gave us a cumulative number of cases reported to you. Yet cases that had findings or rather concluded as a guilty verdict or whatsoever, they are what percent? 2% of the number you were given. And for me, it's very funny. Who would take money and all this time to go to report to a body of lawyers, a lawyer that didn't do anything? Isn't that for you very, very funny and worrisome? Because who would be in a business of wanting lawyers to crumble? Law firms must be closed. I don't think that's normal. It's seriously, there would be, yes, some sinister activity around certain law firms, but it can't be that out of 100% of the complainants, from claimants in particular, all of them didn't have substance to a point where only guilty ones are 2%. It's abnormal. It's very abnormal. That's the request I'm making. I don't want a response. I want them to break it down for us. We received the following cases. This was the evidence considered, and this is the verdict that made it to be dismissed. Then the last one is that, oh, yes, the other one is that you are saying RAF is owing a lot of lawyers and all of those things. That's valid. But at the same time, the very same lawyers do not tell you how did those claims get to a point of not being attended to administratively to the payment. Because RAF's explanation to us is that the lawyers will submit, if, let's say, 10 documents are required, different types, then they will bring 6. And then go back, disappear for 30 days, bring the 7th one. And then disappear for another 30 days, bring the 8th, disappear for another 30 days, then you exceed the time within which the claim was supposed to have been paid. Now, we start actioning the court that RAF is not paying. RAF is not paying us. I don't think RAF will sit
Please
with
wrap
a
up,
cumulative
Honorable Mente.
number.
I'm going to get into trouble with the other members.
Okay, that's the last one. I don't think RAF will accumulate money that is impacting on their liquidity to a point where they are not paying people that they are supposed to pay, because this is not about lawyers, it's about the claimants. And all we have been worried about is lawyers not being paid. Why are they not being paid? Because RAF itself will not be paying people who are not worth being paid. So can we get that list explicitly saying lawyer A was not paid, these are the services rendered, RAF is owing them? Thank you, Chair.
Oh, are we talking about those lawyers who were retained by RAF to act on behalf of RAF, or lawyers who were acting on behalf of claimants that submitted claims to the RAF?
Yeah, I think it's got a 10-minute timer thing. It's got a 10-minute timer thing, Honorable. So, Honorable Mente, can we do this? Can you just explain to the Secretariat will provide the guidance to the LPC? I'm just worried about time for Honorable Kubeka and others.
Thank you, Chair, and greetings to the team from...
Sure, I would ownership.